In this video, I'm going to take a look at the case of Wilson's Hospital School versus Enoch Burke, and in particular the decision by Mr. Justice Alexander Owens in May of 2023 that he made in respect of Enoch Burke's capacity or permission to enter the premises of Wilson's Hospital School, and also the question of whether Wilson's Hospital School were within their rights to suspend him pending an investigation into alleged misconduct and so on. So the decision itself, I'm going to put a link underneath my YouTube video on my YouTube channel to the decision itself. The decision itself is 16 pages long, and there are numbered paragraphs, as there are with all High Court decisions. And in this case, I'm going to just run through the first 31 paragraphs fairly quickly. I don't want it to be boring. I would like people, though, to actually read what the judgment says, and you'll get a lot of valuable information, I believe, about the whole case, about the rights of the employer, the rights of the employee, the dispute, how this whole thing came about, Enoch Burke's permission to, or otherwise, to enter the premises of the school, and so on. Because at the moment, as I make this video on the 7th of January 2024 or 2025, Enoch Burke has had a High Court fine of €1,400 per day imposed for every day that he attends at the school. He attended at the school yesterday, Monday the 6th of January 2025, so that's €1,400 of fine, and today is another €1,400 if he shows up. I have no reason to doubt that he won't show up. I believe he will. But this video is about the decision, the High Court order in which Mr. Burke, Enoch Burke, is in breach of. So, okay, let's have a look at the decision. So, Mr. Justice Alexander Owens made the decision on 19th of May 2023, and we'll just run through the paragraphs. I'm not going to spend too long on it because I would like people to read it themselves, but I want to give a flavour or an overview from the first 31 paragraphs of this decision. Firstly, Wilson's Hospital School is a co-educational school in County Westmeath, blah, blah, blah. 2, the school is separate from the board of management of Wilson's Hospital School, and boards of management of schools have statutory functions, and a board then shall appoint teachers and other staff who are to be paid monies from or provided by the Oireachtas, and may suspend or dismiss such teachers and staff who don't follow the line, as it were, in accordance with procedures agreed from time to time between the minister, the patron, and recognised school management organisations and any recognised trade union and staff association. So there are procedures to be followed by both parties, both employer and employee. Number 3, the board is responsible for teaching activities and the school operates the boarding facilities. The principal then acts as secretary to the board and attends its meetings, but is not a member of the board. In this action, this is the Wilson's Hospital School versus Enoch Burke. The board of Wilson's Hospital School was seeking a declaration that a decision in August 2022 to put Enoch Burke on paid administrative leave was lawful. Number 5, for the board to succeed in the claim, evidence must establish that it acted in substantial accordance with contractual obligations to Enoch Burke in steps which resulted in its decision to suspend him. Number 6, these obligations are incidents of their employment relationship. They include an obligation to comply with rules of natural justice and fair procedures applicable to decision-making by employers and public administrative bodies charged with investigating and determining employment disciplinary issues. The board has a dual role as employer of Enoch Burke and as the body charged with making disciplinary decisions relating to the contract of employment. And notably, the rule which prohibits persons being judges in their own cause is not fully applicable. Number 7, the board seeks an injunction restraining Enoch Burke from trespassing on school premises and damages for trespass. 8, Enoch Burke attended in the school in defiance of the board's decision to suspend him. His stance is that he was invalidly suspended and that he was there to teach. The board obtained an interlocutory injunction which restrained him from attending at the school and from attempting to teach there. He refused to obey that injunction. He was imprisoned for contempt of court. He resumed disobedience following release from imprisonment. Number 9. Enoch Burke was dismissed from his employment by the board on 19th of January 2023 with effect from 21st of April 2023. He has availed of a right to appeal this decision. If his dismissal is upheld, it will become effective. 10. Suspension by a board of teaching faculties on full pay pending resolution of disciplinary proceedings is an interim measure. Suspension continues until the appeal process specified in the employment contract is concluded or until it is lifted. If Enoch Burke's suspension on the 22nd of August 2022 was irregular, the board could reconvene and make a fresh decision. The contractual power of the board to suspend continues until dismissal becomes fully effective. Number 11. Any issue relating to regularity of the disciplinary hearing on the 19th of January 2023 or validity of the dismissal which followed that hearing is outside the scope of this action. Ultimate resolution of disputes between Enoch Burke and the board on whether he has been properly or fairly dismissed will depend on the view of a court or tribunal on issues which are not before this court. A number of potential outcomes are possible from that appeal. One is that Enoch Burke will be restored to his teaching post. Another possibility is that the decision of the board to dismiss him will be upheld. Another possibility is that his refusal to obey court orders restraining him from entering school premises and other conduct will be treated as gross misconduct and that he will be suspended and dismissed by the board on these grounds. So this is an interesting point in this decision, that even if Enoch Burke's conduct or misconduct wasn't sufficiently grave up to this point to justify a dismissal, the judge here is making the point that it is his refusal to obey court orders restraining him from entering school premises and other conduct will be treated as gross misconduct and that he will be suspended and dismissed by the board on these grounds. In other words, they are entirely separate grounds from the original grounds which gave rise to the suspension. 13. On the final day of the hearing of this action, this court expressed a provisional view that, irrespective of whether Enoch Burke's suspension was imposed in accordance with his contract of employment, he is not entitled to trespass on school premises. This issue was considered briefly in the judgment of Murphy J. in Farrell v. Minister for Defence. Number 14. It's appropriate to summarise this court's conclusions immediately. The following matters are established by evidence. 1. The school principal and board acted in accordance with their obligations under Enoch Burke's employment contract in initiating and conducting the process which led to suspension of his employment as a teacher. 2. Enoch Burke did not have consent of either the board or the school to enter or remain within school buildings or grounds after he was suspended. He was asked to leave and he refused to go. His repeated attendance on school premises was trespass. Any judicial finding that the board broke the employment contract in suspending Enoch Burke cannot affect this conclusion. He has no right to enter school premises. 15. On the first day of trial of this action, Enoch Burke was disorderly and in persistent contempt of court. He was excluded from further participation except on condition that he undertake to comply with rulings of this court. During the hearing, he was repeatedly contacted and advised that he was welcome to resume participation if he gave this undertaking. He chose not to respond or to make his intentions clear. As a result of this lack of clarity, some evidence and arguments addressed issues which do not require to be decided. 16. As Enoch Burke's counterclaim has not been advanced, any claims which he makes in it must be dismissed. These include his claim for an injunction preventing continuation by the board of his suspension. 17. This counterclaim also included claims for declarations that the disciplinary process conducted against him was an unlawful interference with constitutional rights and that a report prepared by the school principal was compiled in breach of natural justice and otherwise than in accordance with an administrative circular governing disciplinary sanctions. And that's the administrative circular that's issued by the Department of Education to give guidance to schools as to how disciplinary matters and investigations and so forth are to be conducted. 18. Dismissal of the counterclaim operates as a final determination of all other issues capable of being raised in answer to the board's claim. It is unnecessary for the court to determine claims by Enoch Burke that the board interfered with his constitutional rights. 19. The primary issue presented for determination in this litigation is whether the board validly suspended employment of Enoch Burke as a teacher in Wilson's Hospital School on the 22nd of August 2022. This suspension also terminated his permission to enter school premises. And that's an important point. The primary issue that the High Court was asked to answer here, the primary question was whether the board validly suspended Enoch Burke as a teacher in August 2022. Number 20, a second issue then which arises is whether the board is entitled to a permanent injunction restraining Enoch Burke from entering school premises. If Enoch Burke's entry into school premises is trespass, the board is entitled to assistance of the law to enforce its right to exclude him. The right engaged is that of the board to prevent entry of unwanted intruders on premises under its control and to enjoy use of those premises without interference. 21. It's appropriate to deal with the second issue first. This is because entitlement to prevent trespass does not depend on the outcome of this court's decision on whether Enoch Burke's suspension involves a breach by the board of obligations under his contract of employment. In other words, the court was perfectly free or happy that it could go ahead and make a decision about Enoch Burke's entitlement to trespass on the school premises, regardless of whether he was dismissed fairly or unfairly. 22. Evidence presented to this court demonstrates that mutual trust and confidence between the board and Enoch Burke has broken down because of his actions. He defied the board and the school by attending in school premises. He defied court orders. 23. While it's doubtful whether a court can ever order specific performance of an employment contract, what is certain is that no court will force an employer to provide work for an employee where this essential feature of an employment relationship is absent. Employees who engage in conduct which is calculated to destroy or seriously damage their employment relationships cannot expect courts to disregard such behaviour where this becomes relevant to any jurisdiction to grant discretionary relief. 24. Are employees who have been dismissed, suspended or locked out by an employer entitled to go into their workplace without permission? The answer to this question has never been in doubt. Locked out employees are not entitled to sit in. They may not return to the workplace unless and until their employer accepts resumption of performance of their service as part of an employment relationship. 25. This may happen either by agreement between an employer and a previously excluded employee or because an employer has been compelled by law to reinstate, re-employ or take back an employee. This resumption carries with it permission to return to the workplace for the purpose of enabling an employee to perform duties of employment. This new permission operates prospectively and does not excuse past trespass. A judicial or quasi-judicial finding that an employee has been unfairly or wrongly dismissed or suspended in breach of contract cannot, of itself, confer entitlement to re-enter the former workplace. 26. Employees involved in disputes with their employers often claim that they have a right on their side. Their employers may have acted unfairly or in breach of contract. This does not mean that such employees are given a right to trespass on or cause nuisance to employment of an employer's or enjoyment of an employer's premises. I'll read that again. This does not mean that such employees are given a right to trespass on or cause nuisance to enjoyment of an employer's premises. Privileges and immunities conferred on employees and others by the Industrial Relations Act 1990 in respect of actions taken in contemplation or furtherance of a trade dispute which would otherwise be tortious or unlawful do not authorise or render immune from suit entry onto private property contrary to the will of an occupier. any such entry constitutes trespass. 27. The legal authorities which relate to entitlement of contractual licensees to enter and remain on land have never been extended to give rights to employees who have been suspended, locked out or dismissed to enter their workplace. The reason for this is that a contract of employment is not capable of being performed where an employer refuses to provide work for an employee. 28. Attendance at a workplace by an employee who has been suspended, dismissed or locked out can fulfill no employment-related purpose. No term could be implied into a contract of employment which confers a right on any employee to enter a workplace in such circumstances. Number 29. Courts will not force an unwilling employer to allow that employee to enter or remain on premises as part of a demand to be permitted to continue to work there. Furthermore, courts are obliged to uphold the right of those who control premises to exclude trespassers. 30. Any right of Enoch Burke to enter the school premises is ancillary to his employment duties. Whether his suspension or dismissal were in breach of his contract of employment or not, the board terminated his right to enter the school. He can only return if he succeeds in persuading the board to take him back, or if he persuades a competent appellate authority to force the board to take him back. His claim in this action for that type of remedy has been dismissed. 31. Trespass to land is a violation of the rights of a person who is either in actual occupation or entitled to immediate possession of that land. The former school principal gave evidence that the board controls the school during the school day and that the school is in control outside of teaching hours. This gives the board sufficient possession of school premises and facilities to maintain an action for trespass. The board is entitled to damages for trespass and an injunction to restrain Enoch Burke from disrupting its possession of school property by entering or remaining on school premises and facilities without permission. See Manchester Transport or Manchester Airport plc versus Dutton. They are the first 31 paragraphs of this decision, which runs to 107 paragraphs. It's a decision that is worth reading. It is only 16 pages long, and if you claim or profess to stand with Enoch Burke, or if you claim or profess to stand against Enoch Burke, then I would suggest that reading this decision of Mr. Justice Alexander Owens of May 2023, which deals with the question of A, the entitlement of the board to behave in the way that they did in suspending Enoch Burke, and B, the question of Enoch Burke's trespass on the premises of the school. Those two questions have been addressed in this decision very, very clearly. And as I say, if you have an interest in this case, if you have an interest in this whole Wilson's Hospital School versus Enoch Burke case, then you should treat yourself to having a look at this particular decision. I'm going to put this decision on my YouTube channel. I'll put it underneath the video. This video, there'll be a link down below on my YouTube channel. Read the whole lot if you wish, if you have an interest in it. I hope you find the time to read it. It'll give you a good indication of what the legal position is in this dispute between Wilson's Hospital School and Enoch Burke. Hope you find the video useful. I hope you find it instructive. If you do, hit the thumbs up button down below. Thank you very much.